Great. Happy to be here, if only remotely. Just to note, it's pretty hard for me to hear people in the audience. So I know that somebody was speaking just now, but I couldn't hear any of it. That's just something for future. If anybody wants to jump in with questions, you're encouraged to do so. But bear in mind, I can't hear you. So we'll need to have a mechanism for that. I'm Matthew Scott. I'm based in Sweden. I'm sitting in the headquarters of Raoul Wallenberg Institute in Lund, which is in the south of Sweden right now. I, together with a colleague, co-lead the Human Rights and Environment Thematic area, which focuses on three main priorities. Climate-related human mobility, which is the different ways that people move in the context of disasters and climate change, migration, planned relocation, displacement within countries and across international borders, climate change adaptation and disaster risk reduction, which is to some extent where this right to water comes in most clearly. But also the third priority area is biodiversity and healthy ecosystems. And they're also, of course, the right to water, along with the right recently recognized by the UN General Assembly on the right to a healthy environment is also significant. So what I'm going to talk today about is the right to water and fire. You'll have to forgive me trying to play on water and fire. I couldn't help it. Fire is not the right to fire, and we don't see that reflected in any international instruments. But fire is the framework for integrating rights and equality, which is an analytical and sort of operational framework that we developed over 5 years up until 2022, working with the Asian Disaster Preparedness Center, the Stockholm Environment Institute, and the Swedish Civil Contingencies Agency. And the idea of the framework, which I'm going to show in the next slide, is to make international human rights and human rights-based standards and guidelines more accessible to operational actors, but also to use it as a way to analyze and evaluate realities on the ground in a systematic way. And we've been doing that in a number of different contexts, and you can too by the end of this session. So that's one of the aims of the session, is that you'll at least have an understanding and appreciation of what this FIRE framework is all about. And to help doing that, we'll apply it in the context of the right to water, having a look at the situation in Armenia as well. So here's the outline. We'll work through it. So what's the FIRE framework? And then applying fire to water more generally in the abstract, articulating core elements of the substantive right to water as it's been developed most significantly by the UN Committee on Economic, Social, and Cultural Rights. And then we'll apply those two perspectives, fire and what we call the normative content of the right to water, to the particular situation of water in Armenia, to a limited extent, as reflected in the very recent what's called the periodic review procedure that all countries that are party to the International Covenant on Economic, Social, and Cultural Rights, including Armenia. Armenia just finished the procedure in October of this year, so it's pretty timely. So we'll have a look at that. And then we'll have a bit of breakout to look at two water-related situations coming out of that periodic review procedure before having some more feedback and discussion in a fairly loose way related to what you discussed in your breakout groups. So kind of a reporting back in plenary and giving us an opportunity to exchange on what you thought was interesting. So introducing FIRE. This is it. This is part of the idea of the FIRE framework, is that we wanted it to be accessible on different levels. And one of the ways to make it accessible is to turn it into a visualization. And so the core of that visualization is the colorful part, what we call the 6 dimensions of the framework. A couple of core things to say about the 6 dimensions. First of all, it represents an attempt to synthesize international human rights standards and guidelines on the one hand, with a kind of in the texts that we use to develop the framework, we talk about feminist political ecology, which is basically a way of articulating an awareness of the gender dynamics that take place within social contexts, which contribute to the differential exposure and vulnerability of people on account of their gender, whether that's male, female, or other variabilities or other variables along the gender spectrum. So the core of a human rights legal approach is reflected in 4 of these dimensions. And then the remaining 2 reflect to some extent more coherently this feminist political ecology, or more generally, gender perspective, even though both of the components, human rights and gender equality, cut through all of the dimensions. The source material for these different dimensions is a little bit different. So the specifically human rights-based dimensions include the governance systems and structures dimension, the fundamental rights and equality dimension, the non-discrimination dimension, and the participation and access to information dimension. And I call those specifically human rights dimensions because the standards and guidelines that we consolidated in developing this framework address these dimensions in detail and repeatedly. The standards include things like general comments from international human rights treaty monitoring bodies, and we'll talk about some of those general comments when we talk about the right to water. But we also considered guidance from more operational actors, like the Interagency Standing Committee, which focuses on humanitarian response. There's also the SPHERE standards, which have been developed also for a more humanitarian context, as well as more general sustainable development standards and guidelines. There's one document that I think I haven't referred to in sort of encouraging you to read before this session, but I can share it later in the chat when you're doing the breakout, which identifies specifically which standards we considered in coming up with this framework. But the main idea of the framework is that it takes a pretty large volume of these international standards and guidelines that are designed to, as it suggests, guide in particular state actors in fulfilling their obligations under international human rights law. It consolidates that quite large volume of material into something that is easier to talk about and reference and use operationally. But as I say, we can also use it in a more academic context to structure research approaches. And we can talk about that more too. The other 2 dimensions, the social norms and context in particular, as well as the agency and empowerment dimension, come a little bit more clearly from the gender equality field of knowledge and reflect this feminist political ecology idea. In particular, this social norms and context dimension adds the reality of lived experience to what can sometimes be seen as abstract human rights standards. Even though human rights practitioners engage closely with realities on the ground, sometimes the standards can seem a bit removed from everyday life. And the more social science-based practitioners who spend time in places where environmental harms unfold look at the operation of power within a society. So they'll say it's one thing to have kind of a national policy that says something about gender equality or protection of minority groups, but what's happening in a particular place at a particular time. Who's got power, how are resources allocated, and in particular, what's the gender dimension in this whole context? What kind of work do women do? What kind of voice do women do? How do they participate in decision-making in certain contexts? It's all about the social norms and context, as the dimension suggests. And agency and empowerment is also an important complement to the international human rights legal framework. It doesn't feature prominently in the international standards and guidelines, but it's a core feature of a gender equality approach, moving away from seeing people as beneficiaries or as victims, and recognizing instead the capabilities of communities as well as individuals in their diversity, and encouraging what we call the duty bearers, the state actors, to take steps to empower or contribute to the empowerment of people, recognizing their existing capabilities. And importantly, I think, as I've already said, these dimensions speak to each other. So in some circumstances, you may focus on a particular dimension, but they are meant to be understood as cross-cutting. What you can see outside of the color-coded dimensions are the various elements of the framework. And these elements, I won't go through all of them, but they reflect specific standards that are featured in these international standards and guidelines documents. So they're, if you can imagine this document that I'll share in the chat, it's broken down according to these different elements. So you'll have a section of this document covering governance systems and structures, and then subheadings with these different elements. And then within each of those elements, there are specific standards linked to particular documents from the treaty monitoring bodies and operational actors. So the idea is this is a systematically generated framework that is inductively produced from the existing body of international human rights law and feminist political ecology, gender equality approaches. At the very bottom, you'll see this respect, protect, and fulfill typology. It's mostly a place marker to say, don't forget this important aspect. It relates primarily to the fundamental rights and equality dimension, and it relates to the different kinds of obligations that states have in relation to these fundamental rights, like the right to food, the right to shelter, the right to the highest attainable standard of health, and of course, as we'll talk about today, the right to water. So states, and I'll talk about this in a minute, states have to respect, protect, and fulfill those rights, and there are particular principles related to each of those that we'll talk about. At the very top of the framework, this language to the top left, multi-level and multi-sectoral, comes out of the post-2015 development frameworks, like the Sendai Framework for Disaster Risk Reduction, the New Urban Agenda, the Paris Agreement. These all talk about the importance of looking at multiple levels of society. So even thinking about the international level, the national level, and subnational level, and how different legal and policy frameworks, as well as more diffuse governance systems and structures, shape environmental issues in a particular context. And the sectoral dimension means that we should be having engagements not just with one aspect of society, but all of the related facets of society. We can even add multi-stakeholder to that perspective, because it's not just governments and individuals who have a stake in sustainable development, but also the private sector, civil society organizations, faith-based groups, amongst some others. The final point I'll make just on the FIRE framework is this other dimension up here on the top right, the duty bearers and the rights holders. This is sort of a fundamental framing of human rights, of a human rights-based approach, which helps us to identify the duty bearers, who's responsible for achieving the realization of substantive rights, and the rights holders, which are the people who have those rights to start with. Duty bearers are almost entirely state actors. But of course, it's not just the national government. Duty bearers are also local government actors performing functions, delivering services, making decisions, and things like that. So a human rights-based approach helps us to break down different dimensions of society, social organization, and in particular having regard to the specific role of the state as the actor with the primary responsibility for ensuring the enjoyment and progressive realization of human rights for all persons within the jurisdiction of the country. And for good measure, we've included a few of the core sustainable development goals that are mostly linked to this. I should say that we developed this as part of an initiative focusing specifically on climate change adaptation and disaster risk reduction, but many of the standards and guidelines were derived from more general human rights guidance documents. So the application goes beyond the climate adaptation and disaster risk reduction context. Certainly can apply in most human rights and environment contexts. And basically, and as you can see from this sort of reflection of the Sustainable Development Goals wheel in the very center, it's a framework that I would suggest, and it remains to be proven as we continue to test the model, I would suggest it can be applied pretty much in any sustainable development context, any context where the Sustainable Development Goals are relevant or being considered. You could see whether fire helps take you in a certain direction. I better move to the right to water. But I just want to say one or two more things about the dimensions themselves. For me, they're self-evident because I've been working with them for some time, but it's important to highlight some aspects. When we talk about governance systems and structures, we're talking about, first and foremost, the legal and policy framework of a country. So starting with the constitution all the way down to local government sustainability plans or zoning or land use guidelines and things like that. But also the actors who operate within those governance systems and structures, issues like budgets and resources and capacity, as well as many other issues. Often we associate human rights law with this element of the governance systems and structures, the accountability, transparency, and access to justice element. That's obviously a very significant characteristic of a human rights-based approach. But as you can see from all of these other elements, the accountability, transparency, and access to justice element is only one that may be particularly relevant in some circumstances and less relevant in other circumstances. And we found, working mostly with state actors in the different contexts where we've been using this framework, that the accountability dimension isn't the first one that people want to focus on. But that doesn't mean that it isn't possible to be the main one to focus on. It's just that we haven't used it in that context yet. So think about that. Fundamental rights are those rights that are guaranteed under the international human rights treaties, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Rights of the Child, Convention on the Elimination of All Forms of Discrimination Against Women, etc. I've actually produced a catalog of rights that I can also probably attach in the chat when you're doing the breakout, just for ease of reference. Non-discrimination is a principle of customary international law by this point. There are typically a range of grounds that are identified as being covered by that non-discrimination obligation. Prohibition of discrimination on grounds of race or religion or nationality, gender, age, disability, etc. This is going to be relevant when we talk about one of the cases coming out of the periodic review of Armenia in relation to the right to water. Finally, the participation and access to information dimension. This is a core procedural component of a human rights-based approach, emphasizing the critical importance of people playing a role in decisions that affect their lives. Of course, participation takes different forms depending on the scale. Voting is one form of participation, whereas sitting on a decision-making board in the local government deciding where to locate the irrigation canal is a whole other form of participation, but they're all connected to that fundamental principle. As is access to information. It's quite difficult to have active and meaningful participation without access to information. That was a whirlwind through the FIRE framework. If you want to know more, I encourage you to read the article. It's only 3,000 words that we've published in Climate and Development that explains what this framework is, how it can be used, how we have used it in the past. Time permitting, I'll talk about some of the contexts where I'm using it right now. And there's a number of them. So, but what about applying it to the right to water? Well, if you think about the FIRE framework with its 6 dimensions, one of the 6 dimensions is the fundamental rights and equality dimension, where you can see within those elements certain fundamental rights that are protected under the treaties. The right to food, the right to shelter, the right to water is one of them. It's interesting to note, though, that the right to water doesn't feature in the core human rights covenant, the International Covenant on Economic, Social, and Cultural Rights, but rather it emerged through a process of norm development over a period of decades, finally recognized formally by the UN General Assembly in 2010. What that means is that it is formally recognized as a substantive right, but it doesn't feature in the standard catalog. Whether that makes a difference in practice, I think it remains to be seen, because the first port of call for understanding what the right means is still the Committee on Economic, Social, and Cultural Rights, which was one of the actors amongst many that pioneered the evolution of the concept of a right to water. And they did that through the development of General Comment number 15, which spells out core features of this right. I'll talk to that in a second. I'll just, in the next slide, throw up some of the background, part of which I've already mentioned, before going into some of the core dimensions that are covered in that General Comment number 15. And then drawing a bit on the recent report by the UN Special Rapporteur on the rights to water and sanitation. I'll talk a bit about this respect, protect, and fulfill typology that you saw featured at the bottom of the FIRE framework, talking a little bit about what it means, as well as some other concepts like progressive realization and the minimum core. All of these are tools, ultimately, that you can use to apply to particular factual situations in Armenia or in other contexts in order to articulate what's going on and how things might be improved. So I mentioned already the International Covenant on Economic, Social, and Cultural Rights. You might know it already. It's part of what's colloquially referred to as the International Bill of Rights, which is made up of the Universal Declaration of Human Rights, which is officially, formally not binding because it's a declaration of the General Assembly in 1948, as well as the two legally binding covenants, the one being the International Covenant on Economic, Social, and Cultural Rights, and the other, the International Covenant on Civil and Political Rights, reflecting, as the history goes, a kind of ideological split between sort of the US and the Soviet Union over which rights are important, the liberty rights on the one hand versus the social and cultural and economic rights on the other hand. By at least 1993, it was recognized that all rights are interdependent and interdivisible. But as things unfolded, it took a while for us to realize that. I mentioned General Comment number 15, which is the core normative standard setting document relating to the right to water. It talks about the contemporary, at the time, it's from 2003, talks about the contemporary realities where many people lack access to water and sanitation, and identifies a variety of harms that result from that, which connect to some of those rights that are actively protected in the catalog of rights within the International Covenant on Economic, Social, and Cultural Rights, including Article 11, which is the right to an adequate standard of living, and Article 12 on the highest attainable standard of health, and Article 6 on the right to life. The right to an adequate standard of living expressly identifies the right to food and the right to adequate housing as core features of that right to an adequate standard of living. But both that right and the next right, Article 12 on the right to health, can't be realized, according to the committee and a bit of common sense, without the enjoyment of the right to water. It's not possible to have an adequate standard of living without access to quality or to water of a sufficient quality and quantity. It's impossible to grow food, for instance, or prepare food in that setting without adequate water. And many communicable diseases are transmitted in situations where water is scarce or polluted. To name just two aspects where water is inextricable from the enjoyment of the right to the highest attainable standard of health. We can imagine many, many more. And it was as a consequence of this that the committee found it necessary to articulate in their general comment number 15 the existence of a right to water and sanitation. And it follows that the right to life can be adversely impacted where people get sick because of dirty water, or can't grow enough food because there's not enough water to irrigate their crops. So this is also showing that interconnectedness of different rights and how water sits across many of those substantive rights. And the important the most, I would suggest, important contribution of the general comment number 15 is this normative content, where it tells us what these three features or elements are of the right to water. There's a standard relating to availability, accessibility, and quality. And we'll see and be able to apply this standard when we look at the periodic review outcome for Armenia in the next couple of slides after we get through the content of the right to water. Not much to say about the General Assembly resolution, which formally recognized the right to water and sanitation. It's 3 pages long, mostly preamble, and finally it has, I think, 3 operative paragraphs, one of which says there's such a thing as the right to water and sanitation. Now, this is similar to the recent recognition of the right to safe, clean, healthy, and sustainable environment by the General Assembly last year. It's a significant milestone, but it still leaves a lot to unpack. What does it mean? What's the content? We already have guidance from the general comment number 15, but we need, as the special rapporteur on the human rights to safe drinking water and sanitation tells us, we need more guidance on how to operationalize this right. So writing 10 years after the formal recognition of the right to water and sanitation, the special rapporteur says we need to think of these core features of economic, social, and cultural rights generally and apply it to the situation of the right to water. These core features are those concepts of progressive realization, the maximum of available resources, the minimum core, and non-discrimination. You wonder, where does that all come from? It comes from Article 2 of the International Covenant on Economic, Social, and Cultural Rights, where, to paraphrase, it says states have a duty to take steps to the maximum of available resources to progressively realize the rights protected under the covenant without discrimination. And in order for that goal to have any kind of enforceability, we must conceive of this notion of a minimum core. There must be some baseline below which no state is permitted to allow its people to fall under any circumstances. So not enough resources is not a good excuse for people falling below this minimum core. What that minimum core actually looks like in practice, well, we get some indication from the general comment number 15, which lists, I think, 9 specific components of that minimum core obligation. It's worth having a look at those. I think I have them in 1 or 2 slides down the road, so we'll touch upon it. I'll go fairly quickly through these 3 core dimensions, but it's worth paying attention to them because this is a way of thinking about real life situations from a right to water perspective. So remember, the 3 dimensions are availability, accessibility, and quality. Availability means, where's the water? Well, there has to be enough water, and that's a standard that, if you read the report from the special rapporteur, one cannot place a firm, absolute, unchanging number on. The quantity varies according to the context, according to various personal characteristics, environmental characteristics, livelihoods characteristics, etc. One can have reference to guidelines from the World Health Organization on the minimum sort of water requirement for a human person. But of course, that varies according to age and gender and environmental factors as well. But it needs to be sufficient and it needs to be continuous. And there's no standard that is rigid for everyone all the time. But you can often, in these circumstances, see when the availability of water is not being guaranteed to a sufficient quantity, where people are manifestly suffering from a lack of adequate water. You see it in its absence a little bit. And this is something, when we look at the Armenian context, we will hear people complaining about in one particular context. Accessibility has 4 components: a physical component, an economic component, the non-discrimination component, and an information accessibility component. Physical component means you have to be able to get the water. It may be available, but you need to be able to get to the place where it is available without getting hurt, without that being too far away. And with the accessibility points complying with cultural standards and gender sensitivity dimensions, which of course vary around the world. And this isn't just talking about wells, but it's also remembering that we have the right to adequate water and sanitation. This privacy requirement can relate to toilets, bathing places, etc. So if you're wondering what privacy requirements means in that context, it's not so much about the well as it is about the toilet. The economic dimension is hugely significant because often we see tariffs applied to water access, and people who are in situations of poverty may struggle to pay that amount, whatever that amount is, with the consequence that other rights under the covenant can be impacted. Maybe you've got to choose between water and food if your income is limited, and that obviously is not an acceptable situation. The non-discrimination dimension, as I said, a principle of customary international law. It's always a feature of a human rights-based approach. We're always thinking about how particular decisions or failures to take decisions or to take action impact on different groups within society. And there's a particular obligation on the part of the state to actually take positive measures to address persistent lack of enjoyment of fundamental rights for groups who are marginalized or in situations of vulnerability. So there's a need to identify who's not doing well and to take steps to improve that situation. And finally, the information accessibility connects a little bit to civil and political rights. People have a right to seek, receive, and impart information concerning water issues. So the state has that duty to make the information available and not crack down on people maybe reporting on adverse environmental conditions caused by mining or other polluting industries. So that's accessibility. And quality is almost self-evident. Free from microorganisms, chemical substances, radiological hazards, and not disgusting. So those are the three core elements of the right to water. But remember, I mentioned that the special rapporteur encouraged us to think about the overarching framework of the International Covenant on Economic, Social, and Cultural Rights, drawing attention to these core obligations under Article 2, which require states to take steps to the maximum of available resources to realize the rights under the covenant. And within that framework, over a long period of time, it's been recognized that the duties of states can be broken down into three core duties: the duty to respect rights, the duty to protect rights, and the duty to fulfill rights. And this is articulated here in relation to the right to water, but similar guidance is provided in relation to the right to food, the right to adequate housing, the right to the highest attainable standard of health, and many other rights. So it's a consistent analytical framework that you can apply in different empirical contexts relating to human rights. Don't pollute water is a basic idea for respecting rights. There are many others listed in the guidance. Protecting the right to water means, for instance, regulating the conduct of third parties, non-state actors, the private sector. So it's not enough for a state to say, well, you know, it's on the big company. They need to do better. It's nothing to do with us. The international human rights law framework places very clear responsibility on the state to regulate the conduct of non-state actors. So they can't simply avoid that responsibility by saying, well, it's the multinational corporation that's doing the things that they shouldn't do. We wish it wasn't like that, but it is. And the duty to fulfill rights means that where people are unable to enjoy this right by themselves, the state has a duty to step in. This comes out clearly in humanitarian contexts, but you can also see it in a broader sustainable development context where people are not achieving the minimum core of whichever right is in focus, here the right to water. So the state has to take the required steps to ensure at the very least the minimum core is attained and that progressive realization is taking place. Here's the list of the minimum core. I think for time, I won't go through them. They're in the general comment number 15. So you can have a look at them there, or you can quickly cast your eyes over them now. They're basic principles that reflect those core obligations relating to respect, protect, and fulfill, availability, accessibility, and quality. An important one, I'll just highlight one, is the duty to monitor the extent of the realization of the right. So that's an important dimension here, where the state can't say, we've got no idea. And that's part of the idea behind this periodic review procedure. Once every 5 years, each of the states party to the covenant communicate with the Committee on Economic, Social, and Cultural Rights, as they do with other treaty monitoring bodies for the instruments that they're party to. And they provide a report. They answer questions about what's going on in the country in relation to the substantive rights. And in this dialogue, areas for improvement are identified. Civil society actors can also submit shadow reports to help the parties to further flesh out some of the substantive human rights issues in the country. So this procedure is part of that monitoring dimension. And this is a procedure that Armenia just went through in October. So what happened? Well, not that much in relation to the right to water. Remember that the periodic review procedure is looking at all of the substantive rights under the covenant within one reporting period. The state is reporting on all of the rights, etc. Water comes up, but not very often. The report produced by Armenia in 2020, leading up to this 2023 review, just provides one statistic on the delivery of water, which I've got a slide on next. And then the committee itself asks questions of the state party 3 times in its list of issues. So it produces a list of issues after reviewing the report and says, we'd like to know more about this. So it asks about water in 3 contexts, and I'll show some slides about that, keeping my eye on the time so we've got time for you to break out and talk. So I'll go kind of fast now. Following on from that, we also, or the committee also received input from civil society. And this is going to be the context for our breakout discussions, because one civil society organization highlighted the adverse impact of the Amulsar gold mining project at Lake Sevan Basin as adversely impacting on the right to water. And another submission highlighted the particular adverse experience of the Yazidi minority community in relation to irrigation water in particular. So that last complaint didn't feature in the concluding observations, which is the final document produced by the committee when everything is said and done. But it does identify, sorry for the spelling, pollution of Lake Sevan by mining as a violation of the right to water. It doesn't go into it in much detail at all, which is a bit disappointing, but it's clearly a very serious issue. Now I just have a final note here on the Universal Periodic Review process, which is a separate monitoring function of the UN, where instead of having a committee of experts, the Committee on Economic, Social, and Cultural Rights is about 15 or 17 experts from around the world who can engage with the human rights dimensions addressed by the Covenant. The Universal Periodic Review procedure is states reviewing each other's conduct. And that's in response to complaints by some or many states that they don't really like being reviewed by bodies of experts. They'd rather be reviewed by their peers, the rest of the international community. So this Universal Periodic Review process exists to serve that function. And water doesn't show up in Armenia's 2020 process at all. Is that because it's not a very big issue in Armenia, or is it because it's just not on the agenda of the actors who are engaging in this process? It could be that there's tons of water issues in the country, but those actors who are thinking about engaging with human rights treaty monitoring body procedures aren't in the room. That doesn't have to be that way. Now, I will take 5 more minutes to just give you a snapshot of this, and then you can go away, and I've got instructions to 2 groups to talk about these 2 issues that come up. So I won't spend tons of time, but I'm going to say a couple of things that I think are important to show this analytical framework. This is what Armenia said about what it's doing in relation to the volume of water given to the population. Not spending any time on it. It's just a pure quantitative thing. Doesn't really tell us much of anything about the realization of the right to water. Now, if you're thinking about the analytical tools that you've got from the general comment number 15, as well as the FIRE framework, you could look at this and ask 30 different questions that could encourage the state to give a little bit more information than the volume of water given to the population. Thinking about non-discrimination, thinking about accessibility, availability, quality. We've got urban and rural settlements at least, but what about informal settlements? What about minority ethnic groups? What about the impact of mining, etc.? The committee kind of does that when it provides this list of issues. It says, we want to know a little bit more than that. We'd like to know, in terms of monitoring your fulfillment of the duty to use the maximum of available resources to realize the rights under the covenant, more about the public expenditure. You can see where my cursor is around 5F here. Tell us a bit more on how you spend the money relating to water and sanitation. And they have done that, so I'll show that. And they've also asked a bit more about what you're doing to reduce increasing economic and social inequalities, including in relation to water and sanitation facilities. So where's the money going, and how are you dealing with inequalities? These were 2 of the 3 questions the committee asked. The 3rd question relates to minority ethnic groups. The government provided its budget, showing, and I'm not an accountant, but it looks like something like 1% of the national budget each year goes to water in terms of irrigation and water supply. Not bad on international measures. There's a recommendation that something like 1% should go to water. But of course, if you think about irrigation, there's also questions about where it's located. Is it large corporate farms? Is it smallholder farms? There's always more questions to ask of the data than what you get given. But this is how Armenia said we're spending money on economic, social, and cultural rights, including the right to water. A couple of questions are up here around what else you might ask. And then there's the non-discrimination dimension, where the committee recognizes Assyrian, Kurdish, Russian, and Yazidi minority groups, and asking questions about how you're dealing with their differential access to adequate drinking water, for instance. And the reply is kind of limited. It says we've got a law on ensuring equality before the law. Doesn't really tell us anything. And it's a little bit disappointing that the concluding observations also just basically ignore the issue of differential access to water in the country. But it does say something about the Amulsar pollution. Paraphrasing this, the joint submission of these organizations say mining around Lake Sevan causes pollution. We've done a lot to try and stop this mine, and now it's going to go ahead anyway, and we're really concerned it's going to cause adverse impacts on water quality. Please don't let it happen. So that's one complaint. And the other complaint comes from the Cultural Center of Caucasian Yazidis, who say, we don't have enough water for irrigation. We've got substandard irrigation technology, and it's having a massive impact. In addition, climate change is making this even worse, and there's no indication that anything is being done about it. So people are leaving their traditional homes and going somewhere else. So that raises questions about the positive obligation of the state to prioritize allocation of resources to minority communities who are facing particular adversity. we don't see anything about the Yazidi irrigation water issue in the concluding observations, but we do hear the committee saying, make sure that in your mining, there's no adverse impacts on water quality. A fairly mild encouragement to do the right thing. And that's it. So now, I think Melina and Nona have some papers that you can look at that include those slides I just kind of raced through. It would be good if we take 10 minutes. Melina and Nona can break you into groups, or you can organically do that. And you've basically got the same question, irrespective of whether you're in Group A about Lake Sevan or Group B about the Yazidi farmers. You've got those cases in your mind now, and you've got some papers about it in front of you. The questions to discuss concern which elements of the fire framework are engaged here. That's dimensions, those colorful parts of the framework, as well as the elements, which are those not colorful components. So which parts are relevant here, whether it's in relation to Lake Sevan or the Yazidi farmers. And then when it comes to the right to water in particular, which issues are relevant there? And we're thinking about this core characteristics of accessibility, availability, and quality, the issue of the minimum core, the issue of progressive realization, and the non-discrimination dimension. We're not looking for a 5-page essay, although if you had time, you could do that. Just talk about it amongst yourselves, and then maybe we can have one from each group to break out. If we've got 4 groups to have a smaller discussion, we can have reporting back that complements, and we'll give it, we need 10 minutes. Let's take 10 minutes.
Matthew, can I just clarify something here with respect to Lake Sevan and Amulsar? Amulsar is indirectly related to Lake Sevan because of its this underground tunnel, the Arpa Sevan tunnel. That's how it becomes connected. Otherwise, it's not in the same river basin. But there's other mines around Lake Sevan that is less talked about and is polluting Lake Sevan. So that's the Sotk mine, which now is partly taken over by Azerbaijan, but partly still remains in Armenia. So there's those sources of minerals and former mining sites with their tailing sites, which may be impacting Lake Sevan. So it's a little bit Amulsar. We can make Amulsar the whipping boy, but I think it's a more complex, situation.
I think I read something about Amulsar, like pollution from Amulsar going into a number of rivers as well.
Yeah, that could, if that happens, but that will not impact Lake Sevan, just
Right.
like the rivers. It will impact Lake Sevan if it goes through the Ketchut Reservoir into the Arpa Sevan Tunnel and then goes to Lake Sevan from there.
This is a great point, Alan and everyone, to highlight the critical importance of multidisciplinarity in these kind of complex sustainable development environmental issues. You need people who know the realities on the ground, the ecology, as well as the kind of legal frameworks that can be relevant here.
That's very good, Matthew. I think you highlighted the right point. That whenever you're doing human rights assessment, have some experts involved that know the physics and the geology and the hydrogeology, if it's water that we're talking about.
Yeah, it's inescapable when you're dealing with any kind of human rights issue. You need to have expertise from outside the legal framework to understand what you're talking about.
So we have our Group A and Group B. Yeah. So they spent 10 minutes to jot down their notes on these highlighted items. Is that right, Matthew? Okay.
Yep. And then it looks like we will have just over 20 minutes to sort of report back and discuss. I tend to feel like there's tons to talk about when people are feeding back. So we'll see how we do. It could be good to have a bit of make sure that both groups can feedback, but then we can just talk, whoever feels inclined.
Sure, thank you. I'll post this presentation on the media stream.
And in light of the time, just go for what's obvious as well. So if you're thinking about mining that impacts water, don't feel like you've got to make every part of the fire framework fit. You don't have a lot of evidence or a lot of facts to work on. So just think about what's immediately jumping out.
Matthew, I feel like there's a gazillion questions that I wrote down as you were presenting the fire framework. Almost like there's a separate session of discussing the theoretical challenges like water privatization and right to water and all these issues that countries have to in reality deal with.
Yeah, it's really almost to make a water pun. It's like the tip of the iceberg.
Yep. Frozen water.
And I mean, in terms of the fire framework, one way to think about it is that it doesn't offer necessarily answers to these complex challenges, but it helps to identify the kinds of questions that can lead to relevant engagement. I think
like a diagnostic tool, right?
A little bit, because I mean, as I said before, we often associate human rights with the enforcement and accountability dimensions, or even like the naming and shaming that you see from Amnesty or Human Rights Watch. But often in this space, I mean, I'm coming mostly from disasters and climate change, but more generally, you see so often lack of accountability and lack of effective remedies generally, owing to the political realities or whatever. So what else can a human rights approach bring beyond that kind of judicial accountability framework? And that diagnostic component is relevant. Also, when you look at the submissions to the committee here, those actors who are making submissions are not speaking the language of General Comment 15, even if they're talking about water. So you can see that there are actors who have concerns about issues in the country, but they're not framing them in a way that is accessible to the structure of the monitoring framework used by the committee. So if you can use that framework a bit more fluently, then with that country expertise and subject matter expertise, it can be delivered more effectively.
So that's an interesting point. So could it be that people raised issues, but it just wasn't formatted in a way that people could use it, the reviewers could use it?
Yeah, I think so. Both in terms, you only see what's available on the website, but both in terms of the structure of the argument as well as the evidence. I don't know how much evidence was submitted by the Yazidi cultural organization, for instance. It could well be that this population is suffering massive violations of the right to water, but it doesn't really come through, and it could come through more clearly with a well-articulated human rights-based framework that you could use, that you could develop using FIRE.
I guess you would need to also compare the non-Yazidi communities if they're doing any better.
Yeah,
because my sense is they're not.
Yeah, and then you get the question about rural versus urban areas, which you see the committee engaging with as well. And I mean, another aspect of economic, social, and cultural rights generally is there's a pretty broad margin of appreciation for states, because it's complex policy decisions relating to allocation of resources in a cultural and political and economic context that differs from other countries' contexts. So there's not a clear right answer to how you achieve all of these goals or obligations under the covenant, as well as other human rights instruments. But there is an expectation of that states will consciously and actively take steps to address these different dimensions, which includes that monitoring part. It would be interesting to know what mechanisms Armenia uses to monitor realization of the right to water, for instance. Maybe it doesn't have something in place. Or maybe it just has a quantitative dimension. The flow of the quantity of water to rural areas. But is that good enough when it comes to asking questions about the gender dimension, minority ethnic groups, rural communities versus urban communities?
Right. There's also questions I had. I don't know how much time we have. How are we doing?
I was going to encourage the groups to wrap up. It's too short. Yeah. It's too short, but I think the aim was simply to kind of pull out some of the core features and think about it in a particular context, not solve it.
Yeah.
So if we can maybe we just give one more minute, and then if you have spokespeople, sure. We've only got, unfortunately, 20 minutes as a whole left. So do we have 4 groups or do we have 2?
Two groups, huh? Two groups. Yeah, two groups, yeah.
We've got two. So let's have a spokesperson from
Group
each
A,
group.
do you want to come up here and present?
No.
Yeah, no, not the whole thing. I mean, whatever you've accomplished, it's like in 10 minutes, we can't do much, so. Group A. Okay, Group B is ready. We'll start with Group B, please. Come up here, though. Come up here, because first of all, Matthew can't hear you. Secondly, you're presenting. And stand behind her so you can hear the
Yes.
speaker, yeah. And speak loud.
Hello. Hi. So I'm representing Group B. So our issue was the cultural center of Caucasian Yazidis. And we found that there is definitely a discrimination towards an ethnic minority and availability issue first, because according to this, they used water from 4 springs that later dried up, so it's not available, I'm sorry. And also there's a governance issue, because this has been going on for years, and I don't know if there are any policies in place to handle this, but apparently nothing is being done. So these villages are continuing to empty up.
And you were convinced by the evidence? You were convinced by the evidence that you saw?
Yes.
You were all convinced by the evidence? Did you compare it to non-Yazidi communities and if they're getting better or not? Or it doesn't matter if there's a violation anyway, whether you're Armenians are getting it or not. It doesn't matter, Yazidis not getting anything.
It's a violation anyway, but yeah, because we didn't have time to compare, we can for sure say that this is discrimination.
So
also,
if I can just jump in, so let's say the situation of the Yazidi, as they describe it, is the same as an ethnic Armenian community next door. Are we still seeing a violation of the right to water?
of course,
Why?
because the government should make sure that water gets to them.
Yeah, I mean it goes to that concept of the minimum core as
Yeah.
well, right? I mean, if there's not enough to meet the fundamental requirements of human existence in an environment, then it's like a prima facie. There's a different general comment. You know, the world of human rights is large and deep, going back 75 years. But there's a point about if you see a denial of the minimum core, as we see fairly well reflected in the Yazidi example, the burden falls upon the state to demonstrate that they have taken steps to the maximum of available resources to realize that minimum core. And if they can do that, then they're not in violation of their human rights obligations. It doesn't make much of a difference to the Yazidis who still don't have enough water, but from a legal perspective, the state has done what they could. But we have to ask those questions of the state. What has it done? And we can ask questions about budget allocation. We can ask, like you said, about what policies are in place. Are there policies in place? The only thing we heard from the periodic review procedure was that there was a general policy on, I forget the name of it, but kind of equality of opportunity or something like that. Very general, not kind of action plan for right to water in rural areas, with a particular attention to vulnerable groups, which is kind of what it's the level of action that we might need to see if rural areas are deteriorating in the way described. Sorry, anything else to add on?
Yeah, also the last question about the way the committee dealt with the issue. So we don't think it did because we didn't find anything in concluding observations about this issue. It's talking only about the mining and protecting water, but nothing about getting this water to this area.
Yeah, I'd be pretty disappointed if I was the Yazidi cultural community who made the submission. I'd feel a little bit ignored. Yeah, not all of the issues are addressed. So that's but another point, probably the last point, and then we can go to the group B. But there is this fundamental question, and some people are critical of the minimum core framework, especially when it comes to countries with very limited resources. Because what's the utility? I mean, does Armenia actually have the capacity, if you were to look at its budget, which you have available through this procedure, look at the budget, you can see it's allocating 1% of the budget to water. Can you ask more of the country? I think you can, at least at the level of law and policy. And this is one of the ideas as well, that not every aspect of these substantive rights requires significant financial outlay. The participation dimension has, of course, some resource implications, but also developing a strategy has resource implications, but it's not on the scale of billions. It's on the scale of it's a governance question. So what progress can be made in the governance dimension? And you highlighted that as one of the cores there. Plenty we could talk about, plenty you can look at in other right to water contexts. But for now, we have to instead move over to the Lake 7 group. Unless Alan or anyone else had anything they wanted to say about
I have to intervene here. We
Yep.
had this issue with this minimum core when we're talking to water user associations which distribute water to farmers. And they keep advocating more water for farmers that have poor practices of using water. And okay, so their minimum core is higher than it should be. How do you establish that minimum core is an issue, right? And do you subsidize or supply poor practices, water use practices? And so those issues come up. So when you're dealing with it.
Yeah, and you get, I mean, and this goes a bit to that point that came up about Lake Sevan as well, in relation to the need to have multiple sectors and stakeholders involved in these complex development problems. And human rights can't prescribe the characteristics of sort of agricultural extension projects and things like that, but it can inform some of those initiatives. So finding the right balance between these different dimensions is going to be a context-specific undertaking. And but there are guidance documents, like we talked about. Well, what is the minimum that a person needs for their physiology? Well, there's WHO standards. The Food and Agriculture Organization has standards and guidelines on the right to food, which connects to the right to water. And it has about 20 different themes with specific principles involved there as well, that can go towards answering those really context-specific issues, which are good ones in terms of, I mean, I would be asking, why do they have those poor practices? Is it a question of capacity, agricultural extension? They're complaining in the document about having outdated technology and tools. And of course, there's that balance between the individual obligation to take care of themselves and the obligation of the state to fulfill rights where a person is unable to fulfill them for themselves. That inability is always going to be a vexed question. If they worked harder, could they do it? Or is it something that the state needs to step in, especially in the context of climate change and the need to adapt to it? I think it's good to see that adding a human rights dimension doesn't fix anything, but it does provide a framework for thinking about, in particular, the governance of issues that relate to fundamental rights.
Okay, so regarding the one on Lake Sivan, concerning the non-discrimination, actually here it's not just the health issue is not just impacting on the local communities, but as mentioned, it also the whole population for 4 more provinces of the country is also at risk in that issue. And regarding the governance system and structures, as mentioned in the last sentence, that regarding of the civil society, like they regard it as a disobedience of the civil society against the mining project, and hence they decided to go on with the project and disregard the public opinion, and they extended the contract of it. And the participation and access to information, the text suggests that there was a lack of public involvement and access to information, as evidenced by the shock expressed by the local and the community and the society of the environmental groups regarding the resumption of the work of the Amritsar project. And in relation to the accessibility, of the availability and quality, here the quality of water is actually, since the access to clean springs is jeopardized, so they don't have access to it, and there isn't enough available of clean water resources and healthy environment, as well as the quality. They all they interplay with each other. And for the minimum core is ensuring the basic rights of the clean water and healthy environment and safety for residents may be considered as part of the minimum core as well. And that's it for our group.
Yeah. It definitely connects to the quality element of in terms of fundamental aspects of the right to water. As you were speaking and drawing on this participation issue, and from this kind of realist perspective that we've been discussing, obviously we have states making decisions all the time, and sometimes they're unpopular. So what could we say about this situation? Does it reflect a kind of failure of participation just because the people who were protesting didn't get what they want, or is it something different? What's the failure? The outcome that a group doesn't like, or the process?
I think the failure here is so this is impacting the society as a whole and the health of the civilians that are staying there. So it's a failure when it comes to the priority of the government in place, because they are focusing on the like the outcome when it comes to monetary things, like to the compensation that they're gonna get, and not focusing on the rights of the like, as we said here, it falls under the living standard of life, and this is also impacting their right to life as well. So I think in all is a failure to all the levels, and it's just focusing on their interests.
I wonder, now that we've had the review procedure, this has been put to the committee. The committee has said that looks like a violation. Please make sure as you progress with the mining that things are not good. That the process of extracting the minerals will not have an adverse impact on the right to water and health. Are we satisfied? does it feel like the kind of airing of this concern to the highest international level makes any difference at all?
I don't think it's making a difference on this, but I think on the long term, it does make a difference because there is a pressure when it comes to maybe the standards of the, for them to be playing a part in the international community, especially in Armenia, and ratifying all of these conventions. Maybe not now, but on the long term, it does play a role. I think it will affect long term.
Are there domestic avenues? I don't know much. It feels like this issue of the mining has been challenged quite a bit in Armenia, maybe including through the courts. Does anyone know about that?
I'm not. Yeah, there isn't much coverage on that.
No, because if I was thinking about that issue domestically, I would be thinking, oh, maybe I can pull in the finding of the committee. That's a relevant piece of persuasive authority. It's not binding on any judiciary in the country, I wouldn't think. But it's a treaty that the country has ratified. It would be good to start with the Constitution. Maybe the Constitution includes the right to a healthy environment, or the right to water, or the right to life. That could be the start of a course of action to say, okay, here's the situation in relation to mining. It's having these and these demonstrated or foreseeable impacts on the right to water, the right to health, the right to life. Other rights are also impacted, including participation and access to information. There's the Aarhus Convention, I think, which is also relevant in Armenia on access to information in environmental affairs. So there's a whole kind of legal environment here that can be leveraged in a domestic context, potentially, in relation to that situation. Which I guess, despite highlighting that accountability and access to justice is only one feature of the FIRE framework and a human rights-based approach generally, it can be a very significant feature in certain contexts. And maybe this is one of them. You see that more broadly with challenges to environmentally polluting industrial initiatives all over the world, where you have kind of litigation initiatives brought, class action, or individuals who've been impacted, who have reference to constitutional obligations that incorporate human rights standards and principles. So there's a way to frame that, but it needs good evidence as well. So it's that partnership between the legal framework, the lawyers, and the ecologists in this context, hydrologists, and social scientists. So we need a multidisciplinary approach. Now we're almost at the end. Basically, we're at the end. I hope this introduction, a little bit whirlwind, of the FIRE framework and seeing how this is relevant in the context of particular human right, the right to water, how these frameworks can help to analyze real life issues. And we're out of time. Alan, is there anything you wanted to add?
No, there's a saying in Armenian, when you're saying something and someone sneezes, it means it's that much more correct, what you're saying. Okay, so, all right, well, thank you very much. There's one question from our freshwater ecologist, but we need to wrap this up quickly because there's people waiting to use our Skype thing. Yeah.
Hi, Matthew. Thanks a lot for the talk. Quick question. Whenever we have some sort of a conflict between, say, a human rights issue, access to clean water, clean sanitation, etc., so there is a legal obligation from the states or the authorities to ensure that. But at the same time, there's a massive capacity issue, whether that's a financial issue or expertise, etc. How can we I mean, on one hand, from a legal perspective, there's some sort of enforcement that needs to be done, say by going to court. But when the state says I cannot do this, how are these issues usually solved or progressed, let's say?
Yeah, no, it goes. I mean, it really goes to the heart of the Sustainable Development Challenge. Human rights doesn't fix it. It just provides those. I mean, to some extent, enforceability, accountability mechanisms, but also helping to structure the nature of the inquiry so we can articulate the problem in a way that's aligned with the international standards. We can still get to that point, and often do, I think, where it's like, well, that would be great, but in the reality that we face now, we just don't have any money to do that. So that can also generate some antipathy towards a human rights-based approach, because it's like, well, you know, that sounds very global north priorities that in a resource-strapped country we just can't achieve. So it's pointless talking about it. But I don't think it is pointless to talk about it, even if the resolution isn't immediate. You have that principle of progressive realization, and sometimes there's a space for arguing that resources might be allocated differently. It's not always the case. I don't know Armenia at all, but it's not always the case that the way resources are allocated, even in a country with limited resources, is equitable. Very often we see discrimination against a variety of groups, not least a preference for the urban elite as distinct from rural communities. So it can provide an advocacy tool, but there's also a feature that actually shows up in the minimum core discussion of the general comment about the obligations of the international community. And I highlight this as often as I can, especially as we start to see the impacts of climate change kicking in. The obligation of the international community include financial obligations as well as technical cooperation obligations relating to loss and damage, climate change adaptation, but more generally, international technical cooperation, development assistance. So the money can come from elsewhere as well. And there, the obligation on the state is to seek that international technical cooperation. But fixing development challenges requires more than just a human rights-based approach.
Okay, well, thank you very much. This was great. I learned a whole name.
Thanks so much for having me. And you can look forward to my colleague Claudia next week, I think.
Yes, we are, very much so. All right, take care. We'll be in touch.
Yes, thanks. Bye.
Bye.